Hi, my name is Elizabeth Wente. I'm a partner with Spencer Fane in the Labor and Employment Group, and I focus on kind of preventative measures that employers can take to reduce the potential for employment litigation and to improve their policies and procedures. Employers are still permitted to have drug-free workplace policies, and that hasn't changed. The question really now is, how do employers handle a positive test for marijuana? So for employers that are federal contractors or heavily regulated by federal agencies like the Department of Transportation, because marijuana is still illegal at the federal level, this change likely will not have a significant impact for those organizations. Now, for other organizations, the question really will arise when they have a positive test and the employee claims that they have a permit and that the use was off-duty. Because the way that the amendment is drafted, employers are still permitted to prohibit use, possession, and being under the influence of marijuana while at work. So the question really will come up when you have those employees who have the license or the permit and are engaging in using medical marijuana outside of work. For driving, a lot of those are going to be regulated by the Department of Transportation, and they have a very specific drug testing program that you have to follow. There is a whole set of regulations that govern the Department of Transportation and the drug-free workplace. Now, for other safety-sensitive positions, that definitely will be something that has to be taken into account. The key here is going to be for employers to look at any positive marijuana test on a case-by-case basis, to really look at the full picture and say, what kind of job is this employee in? Are there any indicators that this person was actually under the influence while at work? And that will be important for employers to train their managers on. The managers are going to be key to observing whether or not those individuals are under the influence at work, and also to create some procedures, whether they're written or just practices that the employer follows, to document how they have observed those reasonable suspicion indicators. I think right now it is very much a gray area as to how HR is supposed to handle those situations. We're hopeful that the regulations that are supposed to come out in June of 2019 will provide a little bit more guidance, because the real question comes up when we're asking, what does under the influence mean? So many employers want to take the approach of if a positive drug test means under the influence, but that's not necessarily clear in the way that the amendments are worded. So we're hoping that the regulations will provide some more guidance on what under the influence means. To my knowledge, there is not a test that would permit us to look at the different levels and determine if somebody is under the influence currently, or if it was 30 days ago that they were using medical marijuana. For those employers that have that drug-free workplace policy in place, they can still continue to prohibit the use, possession, or being under the influence in the workplace. The question then becomes, do they have to make an exception to that policy for individuals who have a valid license to utilize medical marijuana if they're doing so outside of work, so off-duty? Right now it is a bit unclear whether or not employers have to make an exception to their policy under the Missouri Human Rights Act. It really comes into question when we're looking at, does somebody have to provide an accommodation for a disability under the Missouri Human Rights Act? And the amendment does not clearly articulate how employers should handle that situation. I'm hopeful that we will see some clarification on the definition of under the influence in the regulations. As I said, I believe those are coming out or anticipated to come out on or before June 4th of 2019. So we will have some more guidance by that point to allow employers to navigate the situation a little bit easier, but I fully anticipate that we will see litigation on this issue in the state courts. If the use is at work, absolutely. If they're under the influence while at work, absolutely. If it is off-duty conduct, so if they're smoking marijuana for medical purposes outside of work, they need to go through a case-by-case assessment and look at factors like, is this employee in a safety-sensitive position? Are there any indicators that maybe they were smoking marijuana outside of work but then coming into work under the influence? So it's really looking at that big picture on a case-by-case basis to make the determination. We recommend that employers have their drug-free workplace policy in place that specifically states that employees are prohibited from using, possessing, or being under the influence of marijuana, including medical marijuana. It's really important that we clearly articulate that in the policy. We also recommend that employers avoid implementing policies or practices where they ask employees broad questions about the prescriptions that they're using. That can get us into an area where we're violating other laws, such as the Americans with Disabilities Act. So just be cautious about how you approach those conversations regarding prescription drugs. Language that we typically see in employer policies is something along the lines of, if you are using a prescription drug that you believe could impact your ability to safely perform the functions of your position, you should discuss that with HR, Human Resources, immediately. So employee drug testing, the legalization of medical marijuana doesn't really change that process. We still tell our employers you should be continuing to conduct your drug testing, continuing to implement your programs. What it changes is how you evaluate that positive test for marijuana. It also changes how you train your managers. So it will be really important, again, to go back and talk to your managers about observation. What are you looking for to determine if somebody is under the influence? How are we documenting that? And Spencer Fane will be offering some training classes on that issue, specifically directed for managers. So we're hopeful to be able to kind of assist in that process. Ask for their prescription or their license, but really other than that, there is no way at this point to determine if it's medical or recreational. No, so HIPAA, and this is an area where we see a lot of confusion among employees and individuals. HIPAA is a law that is designed to prohibit facilities or employers, in some cases, from disclosing the personal health information about the individual. So it's really not applicable in this situation. But employers do need to be cautious when they're asking about those types of issues so that they don't ask for medical information in violation of other laws, such as the Americans with Disabilities Act.